everyone. I want to welcome you to our October Lunch and Learn, where we're going to be discussing elder law and guardianship. And we are delighted to have Victoria Heuler with us. And I see her on and unmuted.
I'm here.
I'm going to give a little bit of bio and then we'll jump into it. So Victoria is the immediate past president, our past chair, excuse me, of the Florida Bar's Elder Law section. And she's been an active elder law attorney since 2000. She is a board certified specialist by the Florida Bar in the area of elder law and has continuously been certified since 2007. And so today she is going to talk about elder law and how it pertains to guardianship and the differences. And so I guess you're going to do more of a discussion. Is that right, Victoria?
So, right. Good afternoon, everybody. Let me first preface, thank you, Dina, for having me today. Hope this time will be well spent. I'm hoping to answer a lot of questions that you all have. I'm on the tail end of a cold or sinus infection, so I have a scratchy throat and a little tickle cough that comes up when I talk a lot. So I apologize. I'll do my best to go on mute if I have to cough, but I wanted you to be aware of that. So bear with me. I really just want today, Dina, to talk about options short of guardianship, because guardianship is often kind of a the community, the medical community, the educational community often presses parents of children with developmental disabilities that have turned into adults, often presses the family to get guardianship. And the family runs to the attorney and says, I need a guardianship, I need a guardianship, where there are often a lot of less restrictive alternatives to guardianship and less expensive alternatives that can be utilized and should be considered. So I really wanted to go into some of those today. And I've also, I know Dina's got some materials she's going to give you all, I think, after the presentation. So I'll just kind of give you the kind of overview of, I'll discuss, but you'll see in the materials even more information. But I also want to just kind of talk a little bit about traditional guardianship too, that is outside of the developmental disabilities type guardianship, because even with that more traditional guardianship, there are ways to have a less restrictive guardianship traditionally if you need that, either for maybe an aging parent or another family member, or even your adult child with a developmental disability. There are times when traditional guardianship needs to be utilized. So do you want me to just keep going?
Yes, sure. And what we could do, if people can, if they have questions, you can put them in the chat and we can answer them.
Sounds good.
And then we could also have people, we could open it up and have people ask questions and just have a dialogue.
Yeah, no, I'm happy to, right. It's really however you want to run it, Dina. I'm happy to have questions in the interim, so I don't mind at all being interrupted. So I prefer a dynamic conversation. I'm here for you all, so I really would prefer that if you have questions, let's get them out there, because if you're thinking it, probably others are thinking it too. So,
right.
Yeah. So I'll just go ahead and start then. I see a lot of participants here today, and so some of you may have more knowledge about this, some may have less. So I just want to start with the concept that under Florida law, when a person needs assistance in decision-making for themselves because of either maybe a birth-related developmental disability, or because of something that happens later in their lives, they have a brain injury, or they have dementia, or some other cognitive issue that creates issues with their own individual decision-making. In Florida, our laws have evolved really, really well. We have some very good, robust laws that govern guardianship and how we need to assist people. And our evolution has gone from just a very kind of no inquiries type guardianship from 20, 30 years ago, where you just say, mom doesn't have capacity, she's old, she has dementia, and you get a giant guardianship, and you really don't have to prove much. That was many years ago. We've evolved now to the law says, look, we don't want to go get a guardianship, go to court, have all this done unless we really need it. So the law has evolved to force us, the lawyers, you as family members, to really investigate, look, do I need guardianship? And if so, why? Or to what extent? So the good news for the developmental disabilities community is there are a lot of less restrictive alternatives to guardianship. And those are the buzzwords, less restrictive alternatives. Because again, Florida law says we've got to investigate things that don't take us into guardianship. We want to avoid guardianship if we can. So for persons with developmental disabilities, there's kind of a schematic of kind of lesser to more intrusive alternatives. So Dina, am I able to share my screen?
One moment and you can. Hang
Okay,
on.
sure.
Whoops. Okay, see if you can share now.
Okay, hang on. Okay, can everybody see, if you're looking at your screens, can you see the supported decision-making agreement?
Yes.
Okay. So let me get back to my main screen here, toggling. Okay. So just this past legislative session, so earlier this year, we have a brand new law. It's actually under the powers of attorney statute in Florida. And this law codifies what some of you probably have already been doing, or at least have heard about, supported decision-making or supported decision-making agreements. So what I've got here is just an example, and this is in your material, so you're going to get this. You'll have it in front of you later to really study. But this is just an example of what could be created on behalf of, honestly, anybody with a disability. So it's not limited to the developmental disabilities community. I think it was initially thought that that was the purpose, but it really is more expansive than that. So you could even use it for someone who doesn't have a developmental disability, again, mom or dad or brother, sister who has dementia, but maybe is on the early sides of dementia. Maybe they don't really need a power of attorney, or maybe they have one, but this is a way to help them express their wishes and get somebody else here called a supporter to, in writing, signed and witnessed, to help them express their decisions and help them be as autonomous and independent as possible, but something in writing with more force and effect of law, right? Because if you take your family member who doesn't have, who has cognitive challenges, maybe can communicate wishes fairly well, but maybe is not immediately understood. Let's say you take them down to the bank and they're trying to talk with the banker, and the banker's like, wait, what? I'm not sure what you're saying. Or, if they have a speech impediment, or they have delayed speech, or, they have difficulty connecting the dots quickly, they may be rebuffed by third parties, So the idea here is for the person who has some cognitive challenges to appoint another person or persons as their supporters and kind of outline some of the things that the person with cognitive challenges wants support for. So you don't make a decision under these supported decision-making agreements. You don't decide for the person you're helping. You're just there to help. You're there to help communicate. You're there to help kind of advocate for this person, to be that other person in the room to make sure that they're being heard, that their wishes are being honored. But you're not deciding. You're just helping. You're supporting. So this agreement, and again, these agreements can be any shape or size. It's just, these are some examples. There's another one in the materials that's like a one-pager. So it's basically just kind of a check sheet. Does the person who needs assistance want you, the supporter, to help with personal care? like helping them make choices about food and clothing, helping them make choices about what support services they may get. Now, a lot of you, if you have an adult child with a developmental disability and that child lives with you, you're probably already doing a lot of this, right? You probably have already put this into place without a document like this. This doesn't work for everybody. I just had a client where we had to get a formalized guardianship. Their child has profound developmental disabilities and is nonverbal. So very difficult for that child to even be able to go through kind of a checklist like this and be able to sign and direct their parents on what they wanted, right? So the parents felt like they really needed the legal effect of a limited guardianship. Really, it's just a guardianship for the person for healthcare decision making, but they weren't able to utilize this less restrictive supported decision making agreement. But it is available for higher functioning individuals, again, not just people with developmental disabilities. They should sign it in front of 2 witnesses and, of course, date it, and it should be notarized. And it has the force and effect of law. So if a supported decision-making agreement exists, and let's just say the educational institution says, I can't share any information with you because this is an adult and they have to tell me that they want you to have the information or they have to sign off on it. Well, you would have this agreement that's signed and has the force and effect of law, and you present this agreement to the educational institution and say, no, this is the law. This does what we needed to do, and you have to honor this. And then there's a process. If they reject it, they have to show why they reject it. There's a period of time that they have to reject it. So there's protections, checks and balances. Other than
Victoria,
yeah,
I'm sorry, if I could
hey,
just add a real quick question, because this is really important. I don't want to
sure.
lose my thought here. So are you saying that if this is completed and we get it notarized and we have all the witnesses and everything like that, this is just as good as perhaps a durable power of attorney that we may have? Is this an
No,
additional?
no,
Okay,
it is
okay.
not, so good question. I don't know if Luz, is that how you pronounce your name?
Yes, uh-huh,
Yeah.
yep.
Good question. It is not the same thing as a durable power of attorney. This can exist with a durable power of attorney,
Okay,
but it is under the power of attorney statute. But it clearly in the statute it says this is not the same thing. It just has some of the protections like a power of attorney would. So this would be another tool in the toolbox. And frankly, this could sometimes be, this doesn't have anything to do with property management. This doesn't, again, this supported decision-making agreement does not give you, the supporter, authority to make decisions. Okay, so you
okay,
can't take this document to the bank. You can't take this document to the doctor to make decisions. You could get information with this document, right? You could get bank records, you could get medical records, you can advocate for your person, but it doesn't give you the right yourself to make decisions. So you can't say, my child's going to have this medical procedure using this document. This doesn't get you there. Okay. So this is just helping your family member have voice, basically, with full authority of law. So that's been the missing piece, is we've known about supported decision making, we've known about documents that might put that into writing and all that, but in Florida at least it's never had the effect of law. And now we have a statute that says third parties, you got to honor this if it's valid, otherwise, and it's signed, and the person needing assistance has executed this. So you can have
okay,
a,
thank you.
yeah, you can have a regular durable power of attorney under, existing law, and that durable power of attorney is for financial, property management, bank account management, all that. That's a separate document where if you are an agent under a durable power of attorney, you would then, under that document, have the right to make decisions for the person that gave you that authority. So that would be in addition to, if you had a supported decision-making agreement, that would be another tool in the toolbox. And so, Luz, that was a good question, because powers of attorney, durable powers of attorney, are a less restrictive alternative to guardianship. So if your loved one has the ability to understand and execute a durable power of attorney for property and financial management, fantastic. You know, if they've done one in the past, maybe they don't have capacity now, but they did one in the past and it's durable, it should be okay today as long as it was legal at the time it was executed. People who have waxing and waning capacity, meaning some days they're sharper than others, as long as they executed the power of attorney at a time when they had the capacity, it doesn't matter if they don't have the capacity tomorrow. As long as they had capacity to understand the document and the granting of authority to another person, then it's fine. So again, some of you, for your family members, that may not be possible. They may have already passed the point where they could really understand a document like that. One of my suggestions is, if you're not sure what your loved one can do, get a doctor involved. Maybe it's their doctor, maybe it's a consulting doctor who has more expertise in incapacity issues and cognitive functioning issues. You know, not all primary doctors are as trained on issues related to cognitive functioning, executive functioning, judgment and insight, you know, our frontal brain. So you would want to get a consult. Here in Tallahassee, we have the Memory Disorder Clinic, which is a really wonderful facility where they do this entire workup. So if you're in a major metropolitan area, you probably have access to something like that. Tampa, Jacksonville, I think Mayo does that, Shands, Gainesville, Tampa, Miami, Fort Lauderdale. I think some of those major metropolitan areas have that available as well. So get experts involved. If you have a loved one that you think, a person with a developmental disability, say, and you think, oh, I think they really could, maybe they could just do a healthcare surrogate document where it's just delegating to you the right to make healthcare decisions if they can't. Those are fairly simple documents. Powers of attorney tend to be a little more complicated. And maybe have your loved one meet with an attorney who's a specialist in this area in guardianship, elder law, capacity, and see if your loved one, see if the attorney thinks they can understand and execute a simple document like a healthcare surrogate designation. So maybe that would be a way, again, less restrictive alternative. Let me talk to you about the existing Florida healthcare proxy law. Most people are not on camera, so I can't ask for a show of hands, but I think probably some of you have heard of the healthcare proxy law and probably some of you have not. So in Florida, we have a backup system for healthcare. We do not have a backup system for financial management. So if there's no power of attorney, or if you know you're not joint on a bank account or have signing authority, especially for like an older person with you know, dementia, that kind of thing, then you would probably have to get a guardianship to get authority to manage the property. But for healthcare, we have a backup. So in most situations, you do not need a guardianship for healthcare. So the healthcare proxy statute, and it's in your materials, it's under a different provision of Florida law, not the same as the power of attorney. It's under a different part. But it says, look, if you haven't already created your own surrogate, healthcare surrogate designation, where you assign to somebody else the right to make medical decisions if you can't make them yourself, if you don't already have that and you don't have capacity to do it now, then there's a system in place, a hierarchy of who gets to make the decisions for you if you can't make your own medical decisions. So it starts with a guardian, if a guardian's been appointed. So if there's no guardian, you don't have to get a guardian. Then it would be your spouse, if you're married. If there's no spouse, then it would be your adult children. If there are no, or majority of them, if there are no children, then it would be your parents. If there are no parents, or maybe there are parents, but there's no one that's willing to act, or maybe they don't have the ability to act, then it would go to siblings, and so on and so on. So there's a list of who gets to decide 1, 2, 3, 4. So it's in the order of priority. So for most of you, if you're the parents of an adult with a developmental disability and that person's not married, they don't have children, there's no guardian, you're the automatic healthcare decision makers under Florida law. You already have that authority. Sometimes what's missing is that the doctors aren't as educated, or the other healthcare providers aren't as educated on the law. And I've had to do this for clients. I've had to reach out to the healthcare team send them a copy of the statute, say, you know, the parents are already the healthcare proxies. They don't need a guardianship. They, you know, they're getting Social Security, SSI for their child. They're dealing with the property. They don't need a guardianship. They're the healthcare authorities and you have to listen to them. So sometimes it's just a matter of education. So you'll have that in your materials. That way, if you do come across this, you can reach out to the doctor and say, look, here's the statute. I have the authority. Just put a note in the medical record that I'm the decision maker. And if it's you and your spouse, the two of you, you know, would have that authority together. So any questions on that?
Victoria, there are some questions in the chat.
Sure. You want to do them?
I think you've covered the one, how is this different from healthcare surrogate, advanced directive, standby guardianship?
Yeah.
We do have one that if the child is nonverbal, how do they fill out the form and the parent or caregiver gets the guardianship?
So to me, I mean, it seems to me that you could be nonverbal, but still have the capacity to understand and have a document execute. So if you're nonverbal, can you sign? You know, can the person sign? Can they type on an iPad? Can they write? What other modes? I think that's a communication issue. So if they can communicate their willingness and their desire to have a supported decision-making agreement, then that's all that's required. And then they would sign and date. What I wouldn't want anyone to do is to take a truly incapacitated person and just have them, you check all the boxes and have them sign it. Like they might be able to sign their name, but they're not really understanding what they're doing. So I'm not advocating at all for that to happen. This really does need to be as much of an autonomous act as possible. Again, if you're the supporter and you're helping them go through, you're talking to them about, I mean, I'm assuming, you know, this person can hear, maybe they are nonverbal. If they can't hear, you know, whatever the modality is for the communication. But if a knowing reply comes back, you know, do you want me to have access to your health insurance, your health insurance information or your health information? You know, yes, or whatever the communication. If that's a knowing decision, that's great. I mean, then you can help, you know, have this form filled out and they can sign it. But again, it has to be knowing, because what we don't want to do is take advantage of someone who has a cognitive disability, right? So
what happens if you do have a child with a cognitive disability? How do you go about getting guardianship?
So, right, if you need to do that, again, kind of try to investigate all the less restrictive alternatives first. So for people with developmental disabilities, and just so you know, I just want to remind everybody what those are. They're a developmental disabilities defined under Florida law. It's the statutory chapter is 393 of the Florida statutes, and there are some materials that you'll get. But here are the types of developmental disabilities that can qualify for a less restrictive type guardianship called a guardian advocacy. So the person has to have an intellectual disability, cerebral palsy, autism, spina bifida, Down syndrome, Phelan-McDermid syndrome, or Prader-Willi. So those are the defined developmental disabilities. Intellectual disability is pretty broad. Used to be mental retardation. I know the ARC of Florida was instrumental in removing the R words some years ago. So I love seeing the history of what you all have done, Dina. You've been very fierce advocates for the developmental disabilities community. So, but intellectual disability oftentimes is kind of the catch-all for other syndromes. I had a client recently where there was some chromosomal deformities, and it didn't fall under any other categories, but the child had an intellectual disability as a result of those chromosomal defects. So you can use what's called a guardian advocacy. That is considered a less restrictive alternative, because without a guardian advocacy, you would have to go to a bigger old style traditional guardianship, which would be much more intrusive. So with a guardian advocacy, You all as parents or family members, you can file for your own guardianship if you feel confident enough to do that. I just had this happen in one of our local counties up here. I'm in Leon County. The next door county is Gadsden County. It's a little more rural in Gadsden. So in Gadsden, the clerk turned away a parent, said you can't file on your own for guardian advocacy. You needed a lawyer. I said, that is absolutely not correct. And you have the statute in your resources here. I said, no, the parent's allowed to file on their own. And I was able to help the parent. The judge and the clerk got involved, and the parent, I sent the judge the forms. The judge had the clerk put them on the website for the clerk, and the parent was able to, within just like a day or two, able to file their own petition to be appointed as the guardian advocate for their developmentally disabled adult child. So you definitely can. Not every jurisdiction has the forms available. They are available through multiple of the resources that I note in my materials, Dina. But if anybody needs those forms, there has to be a petition. So basically, a petition is just asking the court to do something. So you petition the court to be appointed the guardian advocates. There's an application that you have to file to be a guardian, just outlining who you are, your employment history, not forever, 10 years. You can't be a convicted felon. So if you're a convicted felon, you can't serve as a guardian in Florida. You can have some mental health history. I mean, as long as the judge doesn't think there's anything really troublesome, then, even a history of some counseling or mental health, even bankruptcy. I've had clients with all of those. And as long as you're not a felon and you're a family member, there's no other issue, you're going to be appointed as your child's guardian advocate. So the way you create the guardian advocacy, you can minimize it. So person and property, that's how we have a guardianship, right? We need either person, so medical, social decision making sometimes, and residential. Those are the three main personal rights. And then property would be, bank accounts, real estate, personal property, stocks, bonds, whatever, cars, that kind of thing. So a lot of my developmental disabilities clients do not have property other than they get the Social Security, supplemental security, and Medicaid. So that can be dealt with. We don't need a guardianship for that because Social Security issues the payments, and they will make one of you the representative payee through the Social Security system. You report directly to Social Security. You don't have to report to the guardianship court. So that's just kind of outside over here because Social Security manages their own money. So you really, in that case, would only need a guardianship of the person, probably for healthcare and maybe residential, where this person lives. Social usually is not a big deal. If it is, you can ask the court to designate to you the right to make the child's social decisions if there's some dynamics where you're fearful that the child is hanging out with the wrong people, is being unduly influenced, things like that. But again, if you have only a guardianship of the person and no guardianship of the property, that's less restrictive. So you've done a good thing there by minimizing the extent of the guardianship. I will tell you that I've had some developmental disability parents who wanted the traditional guardianship. It's rare, it's not that common, but where we have to go through an actual evaluation through 3 experts to determine what the incapacities are. And then we actually remove rights. And the reason some of these parents have had to do this is because they've had higher functioning adult children who have wanted to get married or do things like that, where a guardian advocacy doesn't have anything to do with the right to marry. It won't remove the right to marry, and it won't remove the right to contract. So marriage is a form of a contract. And so we've had to go the traditional guardianship to get those findings and to remove the right, because the right to marry in these extreme cases has been subjecting this person to exploitation, essentially, and undue influence, where the person was really not capable of understanding the marital contract and all the things that go into marriage. So more extreme, but you can use the traditional guardianship if you really need to remove rights so that your loved one can't exercise that right and can't be, harmed by a third person.
Hey, Victoria, what about for those individuals that are in group homes?
Can you repeat the first part?
Can the group home provider or the waiver support coordinator be a guardian advocate or supporter?
No, I don't think so. That seems to me a patent conflict of interest. I know that the group homes oftentimes will handle the role of representative payee. They don't have to, but I know oftentimes they do, and then they have to keep a report of how they spend the money, and the family members should be able to get those reports from the group home. But no, that to me is a conflict of interest. To the extent that there's nobody else, we do have public guardians available who can serve. Most of our areas of the state do have a public guardian available. We have one up in North Florida. I think Karen Campbell serves the Jacksonville area as well, and I know you all have public guardians over there. But yeah, if there's no other family who will serve, then public guardians are available, and so there's no charge to anyone who meets the indigency requirements, which is basically the Medicaid requirements, $2,000 or less in assets and Medicaid limited income. Otherwise, there are professional guardians that can serve for people who do have resources and can actually a paid guardian could come in. But no, those facilities have no business being guardians because it's a conflict because you're providing the services and trying to be a guardian at the same time. And so you got both hands doing the same. You can't do that. I would definitely fight against that if someone's trying to do that. Any other questions that have come up?
No other questions right now in the chat.
Okay. So let me say this so again, you can seek your own guardian advocacy if you want to petition for yourself. And Dina, let me know later if you want me to send you those forms, I can do that.
Sure. We'll include, everything when we send it out.
Okay. Yeah. I didn't include the petitions or anything in what I sent you, but just email me and remind me and I'll do that. I have clients who they will retain me to start the guardianship, kind of move that process forward, because most people are not familiar with the court system and they don't want to have delays and they don't want to get have the clerk tell them you can't do this, you can't do that. So people will hire me to get it started, get them appointed, and then they will do their annual reports that are due. Again, if you're just the guardian of the person, it would be called an annual plan. And all you do is every year you tell the court where the person under guardianship lives, what their medical treatment is going to be, any issues that have come up, etc. It's a form report that you fill out. Most people can do that on their own. They just have to remember the deadline for it. And so a lot of our guardian advocates will do that on their own, and then they'll keep me on board just to kind of check in if they need to, but basically it just keeps the cost down so that they only check in with me if they need me, but they're pretty autonomous. And then other clients, they want me to do everything. So they're okay paying, and it's not a lot of money because we're not really doing much after the initial guardianship is created. So again, we're here more for the questions that come up or any kind of just unusual things that may pop up, or if the court has questions, they want us on hand. So you really have kind of a lot of options. If you feel like you're much more autonomous and you want to do it yourself and go get your own guardian advocacy and then do your own reporting, you can completely do that. If your adult disabled child is indigent, which most of them are, you won't even have to pay the filing fee because the clerk always charges a fee to open a court case. But if your child's indigent, they're going to be the ward under the guardianship. You won't even have to pay that. So it could be very inexpensive if you're willing to do it yourself. And that's a nice thing. That does not exist for traditional guardianship. If you go the traditional guardianship route, you got to have a lawyer. It's a court case. It's all that. But the law has evolved to really help families with developmental disabilities to try to make it as easy and as streamlined as possible because your lives are already difficult enough. So this is designed to really try to help support the families. Okay, emergency temporary guardianships. This doesn't come up in the context of developmental disabilities guardianships typically. You can't have an emergency guardianship in a guardian advocacy. And the reason is because the statutes tell us that we have to file what's called a petition for incapacity in order to have an emergency temporary guardianship. So that's the traditional guardianship side of things. Now, there might be a time when you think, again, exploitation is happening or something else emergent is happening. This happens sometimes with people with mental health disorders, that like bipolar disease, and they're not taking their medication anymore, and so they're not thinking clearly when they're off their medication. So sometimes an emergency temporary guardianship is the answer to deal with the problem that exists, but you don't have to have a long-term guardianship. So you file, again, you got to hire a lawyer to do all this, but you file a petition to determine the person's incapacity. And so some experts are appointed. And you also ask the court for an emergency but temporary guardianship. It only lasts for 90 days. Or it can be extended another 90 days if necessary. Deal with the problem within that short period of time, maybe get the person back on medication. You're now the guardian, you've got more control. And once the problem's dealt with, oftentimes we can dismiss the incapacity petition and close down the emergency guardianship if everything is back, where it needs to be. So that can also be a form of a less restrictive alternative. So even though you have a person with a developmental disability, if there's some circumstance where the guardian advocacy is just not working or wouldn't work, you could do the emergency guardianship, deal with the problem, and then get rid of that once the problem is solved. So there's sometimes where you would want to go into the traditional guardianship world. Questions about that? There's also in the traditional guardianship world, and anybody who has the capacity can use this guardianship, but it's only for the property. So voluntary guardianship, you have to know what you're doing. It's kind of like a court supervised power of attorney. So you, as the person creating the voluntary guardianship for yourself, you have to understand the delegation that you're giving some authority to somebody else created by the court. And it's because of the infirmities of aging or something like that, but not because you lack capacity. If you lack capacity, you can't have this guardianship. But it's nice for people who find themselves physically infirm, but still mentally intact, and they want kind of a court supervised scheme so that they're protected, and maybe they have to have a professional involved. Maybe they don't have any family that they could appoint under a power of attorney. They could use a voluntary guardianship, have maybe a professional guardian assist them. That person now is under the court supervision, manages their property, has to report to the court, does accounts to the person that creates the guardianship, the whole 9 yards. So it's really nice that that's available where it's necessary. Again, only property, doesn't apply at all to healthcare or anything like that. And the person that creates the guardianship for themselves, again, you'd have to hire a lawyer, but they have to have the capacity to do it for themselves. So it can't be forced on them. So those are the kind of big picture, less restrictive alternatives. Some of the others would be adding authorized signers to bank accounts. Again, the person with a developmental disability, if they have the ability to do banking for themselves, or to authorize, again, under supported decision-making agreement, authorize somebody to help them communicate what they want to the banker. They could potentially add someone as a authorized signer to the account. That could help to help manage the account for the person, to have somebody else on there. I will tell you, huge warning on that. Most banks these days will only put another person on your account as a joint owner. They are not adding people any longer as convenience signers. And here's the difference. If I'm just a convenience signer, I'm allowed to sign. So I guess I could write a check to myself if I wanted to, which would, by the way, be exploitation unless it's on the up and up. But if I'm writing a check to myself, that's it. I'm sorry. Let me go back. If I'm writing a check to a third party and I'm authorized as a signer, that's fine. If I'm an owner of the account, when you die, I get all that money. So, or if I have creditors, my creditors now can get after, that money, or your creditors can get after that money. So joint accounts come with a lot more risks, whereas a convenience signer is limited to just being able to transact business on the account and not become an owner of those funds. So, just be careful, because if you go to the bank or the credit union, almost always they're going to add you to your loved one's account as an owner, and that may not be in keeping with that person's wishes. So if it's like an older adult, maybe with dementia, you're added to the account. Let's say you're a child of your parent, and maybe you've got 2 siblings, you're added to the account just to help mom or dad, right? Mom dies, you're now the owner of mom's $100,000 account, and your 2 siblings get 0. So you can see how that can cause a lot of problems. If mom said, I want all my kids to share equally, or if her will says all my kids share equally, that's a problem. You might share the $100,000 with your siblings and make it all right. But I'm just telling you, it can create a lot of havoc. So just be really careful when going to the bank. Insist that it's a signer only, not a joint owner. Okay. So, other questions, Dina?
The only other one in the chat, can a caregiver be set up with a supported decision-making agreement?
A caregiver, as in, well, I mean, someone who's a paid caregiver?
Paul, you want to unmute and ask your question? Or clarify?
It's okay. Maybe I'll just, if it's a paid caregiver.
There you go.
Yeah, the answer is yes, it would be a paid caregiver.
So are you related to the person that would make the supported decision-making agreement?
No.
No. Okay.
We do have, we also have the guardian advocate status with our daughter.
But would your daughter be the one making the supported decision-making agreement?
No.
No. Okay. So my concern would be if you're a family member and you're also getting, I know APD has kind of a family caregiver compensation, packet or whatever. It depends on the level of APD services. So if that's you, I'm not so concerned about that. If it's a truly paid third party, non-family member caregiver, I would be concerned about a conflict of interest. That's not to say that the person with the disability couldn't. I mean, that's their choice, right? I think it's more of, from the paid caregiver's perspective, that conflict of interest is something to consider anyway. I'm very conservative when it comes to things like ethical problems or conflict of interest issues. I just like black and white. Like I do not want to deal with gray if possible, because it just keeps things a lot simpler for both sides. But if the person with the disability says, I want this caregiver to be my supporter, and has the ability to create this to sign this document, list their choices, sign it with witnesses, that's their choice. So, I think it just needs to be considered, are there conflicts of interest, and are they disclosed to the person that's making this agreement? I mean, I'm assuming those conflicts would be disclosed, because they would know, you're not my parent, you're not my family, you're a paid person, but I still want you to be my supporter. So the answer is yes, you can do it, but I think there's just needs to be a discussion about potential conflicts of interest.
Do we have one other question in the chat? How do you set up guardianship for an individual that is a client of APD that's deemed incompetent without family?
So, any interested person can petition for guardianship. So the question would be, is this an institution that's going, like APD is not petitioning, right? It would just be someone else who's interested in the welfare of this person would petition.
That's what it sounds like, yes.
So you can petition to be the guardian. You know, you have to pass the qualifications. The courts routinely require a credit check if you're guardian of the property, and also a background check to make sure you're not a child abuser or abuser of the elderly. So if you pass that criteria, you could be appointed. Not if you're a provider, if it's APD, no. If it's just you're a fan, you know, you're a neighbor or somebody, you know, who's interested in this person's welfare, you can petition to be appointed as the guardian advocate. And then what we have to use for proof of the developmental disabilities, typically an IEP report, psychological reports, some kind of, you know, medical history that just pinpoints the diagnosis that meets the criteria of a developmental disability. So we don't have to call experts. At least up here, our courts never require us to have the doctor testify or the school, you know, social worker, the teachers. Nobody ever has to testify. The documents themselves are sufficient. Again, it may be different in other jurisdictions, but up here we don't ever have to bring experts. The courts take the school records as evidence, medical records, psychological records of the developmental disability. The parents can certainly testify, or the people with knowledge, but the hearings are very efficient, usually very short. The judges really have a good appreciation for the needs of the family and the fact that we want to get it done quickly, less restrictive, efficient, less expensive.
Great. Does anybody else have any other questions or comments? We have about 9 minutes left. Feel free to unmute yourself.
I encourage you to go through the packet when you get the information, and really there's a ton of resources. A lot of them are duplicative, but there's just a lot out there. And go through, I provided a document pretty short from Stetson through the Wings project, and there's a 2-page exploring my decision-making abilities worksheet. It's kind of like the supported decision-making agreement, but more just kind of a check sheet to go through with your loved one to see, you know, what kind of things they want to do for themselves, what they might need help with. You know, and the idea is just to help our loved ones be as autonomous and independent as possible. I know this is easier said than done in many cases. And I do know it does take more time and effort to have a decision-making agreement like this. Sometimes guardianship is just faster. And the problem out in the community is that still third parties don't understand less restrictive alternatives. So we're constantly having to educate that we don't have to have a guardianship. So you all can help with that too, and just tell people that you interact with that that's simply not true, you know, that there are a lot of alternatives. Well, I saw some kind of pop-up, Dina. What was that?
Nothing. I had to stop the screen sharing to see if I could
Oh, okay, gotcha.
look at anybody's hands or raised or
Gotcha.
anything. So.
Okay.
Okay. Well, we certainly appreciate you taking the time to talk about this, and we will send out all the information that Victoria referenced to all the participants. I will include Victoria's contact information. If anyone has any other questions, just let me know. Otherwise,
Yeah, happy to answer those. Yeah.
we will see you in November. Thank
Thanks
you
for
all
coming.
joining.
Thank you, everybody. Appreciate being here.